Welcome to Transnational Competition Law course. And dear learner, today I am going to discuss the doctrines and principles of extraterritorial application of competition law in European Union. It has been discussed during the last lecture that what remains the ambit and scope of extraterritorial application of competition law in European Union, and I have prefaced the entire synopsis of my lecture, which covers the entire intricacies, the legislative framework, the economic entity doctrine, and the application of implementation doctrine through the catena of cases decided by the European Court of Justice. Today, I am going to discuss that what besides these two doctrines, which has been in practice and vogue in the European Union and European Court of Justice, have categorically recognized the single economic entity doctrine and implementation doctrine. What is the place and location of the effect doctrine of United States antitrust or the competition law on the soil of the European Union and the conglomerate of 27 countries? To what extent the economic doctrine, effect doctrine finds a mention under the European Court of Justice? And we will also examine the fact that the settled propositions of law on the extraterritorial application, which has been legislated under Article 81 and 82 of the Treaty of Rome 1985. Secondly, the chapter 1st and 2nd of United Kingdom's Competition Act 1998. And thirdly, the Article 101 to 109 of Treaty on the Functioning of European Union 2009. How these three legislation and the slew of legislative reforms in the European Union competition law, in the light of the catena of the cases handed down by the European Court of Justice, have shaped the single economic entity doctrine and the implementation doctrine. It remains far from settled, and it happens to be beyond any reasonable doubt that these two doctrines has been judicially recognized. Now, in this lecture, dear viewers and learner, what we are going to understand that to what extent the effect doctrine of the United States antitrust law finds a mention in the European Court of Justice decisions, to what extent the effect doctrine in one form or the another, overtly or covertly, looms large in the European political elite, and the vociferous criticism which has been offered against the effect doctrine somehow reflect in some of the very notable decisions of the European Court of Justice. And we will also look as to whether besides the implementation doctrine and the single economic entity doctrine of the European Union, the kind of the desideratum and the void can be filled by the effect doctrine, or altogether these three doctrines which has been handed down by the European Court of Justice, leave apart, we have to see in a very dispassionate manner the principles of comity and the principles of cooperation and its consequent judicial recognition as a matter of a separate doctrinal framework or legacy to see how the European Union's competition law are being fostered among the 27 countries. We will also try to examine that in juxtaposed to the three doctrines, namely the single economic entity doctrine, implementation doctrine, and the effect doctrine, can we see the extraterritorial application of competition law beyond the window and purview of this doctrine, and we should harping back to the basic tenets of international law and international principles of jus cogens, and from that prism can we look at the principle of comity as one of the most revered principles of international law and its judicial recognition and responses vis-a-vis the spirit of cooperation among the member countries as a better alternative, as a better discourse, as a better mechanism, as a better way of reform, and a better framework to understand the extraterritorial application of the competition law in the European Union. And we will find that how, in opposition to or in contrast to the three doctrines, namely the single economic entity doctrine, implementation doctrine, and effect doctrine, the extraterritorial application of competition law in European Union is still the march of its applications and enforcement under the principles of comity and the principles of cooperation, and partly some of the overture and covertures of the effect doctrine in giving a driving force behind all antitrust cooperation at multinational antitrust fora, and how meticulously and how beautifully it tried to fill the void and the philosophical gulf which is being created by this doctrine in the implementation of the transnational and extraterritorial competition law in European jurisdiction. With this, dear learner, we will straightway try to understand the effect doctrine, although it's not an occasion to dwell in detail some of the basic rubrics of the effect doctrine, because my previous lectures to you on the extraterritorial application in United States, we have dear learner, in my previous lecture, you may well recall and vividly recall on the topic of extraterritorial application of competition law in United States. We had a very elaborate discussion on the effect doctrine, and I do not want to again highlight some of the basic and salient features of the effect doctrine. Nonetheless, it appears that some of the finest Nonetheless, it appears imperative for us to find some of the broad features of the effect doctrine and its application in the European competition law in right perspective. Dear learner, the third doctrine in the extraterritorial application of the competition law is the effect doctrine. This doctrine has a trigger effect or triggering doctrine in the sense that the purpose of asserting extraterritorial jurisdiction is primarily based on economic effect. As the very nomenclature of the doctrine suggests, effect doctrine, it tries to see the effect, not the source, not the supply. Therefore, the triggering, it's a kind of a triggering doctrine in assessing the extraterritoriality of the competition law, and it is simply based on the economic effect which is felt within the European community or the European Union. Though the effect doctrine has been recognized and accepted by the Commission, European Commission, the testimony of which is borne by the dicta of various Commission decisions and Commission's notices. Sorry. On a deeper analysis, what we find that the European Court of Justice has never handed down a judgment explicitly affirming the effect doctrine, but preferring to rely more on single economic entity doctrine and the implementation doctrine in the name of the convenience approach and the expediencies of its administration across European Union, or you can say the demands and the precepts of the political economy in the European Union, and it tries to shy away from all kind of a political controversies of application of the effect doctrine in the arena of the European Union. However, the effect doctrine has not been formally recognized by the European Court of Justice, but the subject matter of the jurisdiction, the right which states enjoys over the institutions, and the very process of making their laws applicable to antitrust and competition activities leads to some kind of a manifestations that either it is the interest of person or the interest of the property, be that the status of the people or the relationship with the other countries, in one form or the other form seems to have an effect on the entire implementation and enforcement of competition laws and policy in European Union. This can be better understood when we see Article 81 and 82 of the Treaty of Rome 1985, what we see that Article 81 and 82 of the Treaty of Rome 1985 is the cardinal legislation in European Union, and it well lays down the rules by administrative agencies and by the courts. Therefore, in the entire enforcement of the competition law, what we find that the enforcement jurisdiction of the competition law obliquely refers to the effect doctrine. On the other hand, we can say that the power of a state or any competition bodies induce or compel for the compliance or to punish for the non-compliance. On an examination, we find that in some form or the other, the effect doctrine has been adopted and incorporated. Therefore, the very nature and trend of the European Court of Justice and its judicial stand vis-a-vis the effect doctrine is attributed to the entire European political thinking, and at some time it has been castigated and criticized by some section of the business commentators and the corporate lawyers and jurists in opposition to the antitrust laws of the USA. But to dispel our misgiving about such scathing criticism of the effect doctrine in the European Union, we are bound to refer and to understand in right earnest and in a logical manner the Dyestuffs case. The effect doctrine resonates in the Dyestuffs case very well, as it has been vehemently articulated and marshaled by Advocate General Mayras while the hearing of the Dyestuffs case. The Advocate General's fervent view happens to be that the effect doctrine should become the cornerstone of European communities or European Commission or European Union's competition law. His observation that it should become the cornerstone of the European Union's competition law carries wider import and has a ripple effect on application of the effect doctrine in the extraterritorial jurisdiction of the competition law in European Union. Thus, Advocate General Mayras says that in a vast majority of the cases, the effect doctrine has not been formally recognized, but by the practice, by the convention, by the gestures, by the tone and tenor, the European Court of Justice happens to manifest a vast bearing of the effect doctrine in matters of asserting jurisdiction in extraterritorial manner in any competition law case. Thus, the jurisdictional response to challenges imposed by the globalized world and economies demands effect-based approach, which is very simple, which is very handy, which is very clear, very succinct, and arguably that it is based on an approach which has been manifested in European Court of Justice decision in Intel case. Therefore, the underlying tenor and tone of the effect doctrine call to meet new challenges in the European Union, and it calls also for new thinking and reconceptualization under the implementation doctrine. Dear learner, besides the manifestation of effect doctrine in Intel case and the vociferous argument of Advocate General Mayras in Dyestuffs case, we will be looking at the wood pulp case and try to see that how the European Court of Justice, by applying Article 81 of the Treaty of Rome, happens to see all relevant factors of the pulp producers and trade associations as to what extent they have infringed Article 81 of the Treaty of Rome 1985. The totality of the circumstances and the factors taken together in wood pulp case finds that the European community have recognized overtly or covertly, directly or indirectly, the application of effect doctrine in the European Union and community. The European Commission have made an explicit reference to the effect doctrine in agreement, in practice, in matters of price fixing, in matters of cartelization, in matters of customers' welfare, in matters of resale of the pulp within European Union, and therefore it becomes apparent and ostensible that in wood pulp case, the European Court of Justice have a great tilt towards the effect doctrine. Dear learner, it is very appropriate at this juncture to refer, as we refer to Advocate General Mayras' opinion in Dyestuffs case, it equally become important and of seminal significance to refer to Advocate General Darmon opinion in wood pulp case, who espoused and advocated for effect doctrine, reflecting a belief among several advocate generals of the European Court of Justice to adopt that doctrine should become an established concept of extraterritorial application of competition law in European Union. In this reference, Advocate General Darmon's view about the effect doctrine is having a far-reaching ramifications, and in particular what he opined, and I just quote, "There is no rule of international law which is capable of being relied upon against the criterion of the direct, substantial, and foreseeable effect." Direct, substantial, and foreseeable effect, and his emphatic reliance on the criterion of direct, substantial, and foreseeable effect by Advocate General Darmon in Wood Pulp case carries a lot of weight and happens to be in consonance with the principles of international law, and thus as to why not that the effect doctrine should also be made applicable to the extraterritorial application of competition law in European Union. Dear learner, as I stated in the beginning, that besides these three doctrines of extraterritorial application in European Union in matters of antitrust and competition law, we have to refer to the principles of international law, and one of the principles happens to be the principles of comity. That needs to be understood in details as a filler, as a desideratum, as an alternative, as a concurrent, as a parallel kind of an arrangement in matters of application of competition law. There is no doubt that the assertion of extraterritorial jurisdiction can tantamount to impingement of sovereignty, but the unilateral assertion of extraterritorial jurisdiction has come to the fore under the principles of comity as a filler. According to Organization of Economic Cooperation and Development, the concept of positive comity, there are two kinds of comity. The one is the positive comity and another is the negative comity. And the concept of positive comity ordains that a voluntary policy of calling for a country to give full and sympathetic considerations to other countries' important interest while it's making decision concerning the enforcement of its own competition law. On the other side, we find a negative comity which enunciate that a country's consideration of how it may prevent its law enforcement action from harming another country's important interest, then the comity of negative comity comes into picture, and the principles of comity does form an integral part of the European Union's bilateral antitrust cooperation agreement with many countries in the world and the globe. Thus, the Organization of Economic Cooperation and Development's prescriptions of positive comity and the negative comity, we look again that the entire competition law enforcement in an extraterritorial context comes under the comity principles in European communities. And to buttress this point and argument, we have to see the entire panoply of the competition authorities. Most notably, we refer to the national competition authorities and European competition network. These two administrative bodies have applied the comity principles in European Union in all kinds of matters of trust and competition. And this can further be gauged and buttressed by the decisions of the Microsoft, GE and Honeywell case, and the Commission's European Court of Justice and European Commission's decision in Microsoft and GE Honeywell case further corroborate that how the principles of comity has been recognized in competition law matters as one of the most revered doctrines in European Union. So, in a greater sense, we can say that the conflicts are rare and occurrences of cooperation between the European Union and US and other countries under the principles of comity have seen great successes. And principles of cooperation as a part of the international law. Thus, these two principles, principles of comity and the principles of cooperation, is acting as a driving force behind all antitrust cooperation in multinational and antitrust fora. As a corollary, what we find that the effective spread of the best practices, the effective spread of the best practices of the extraterritorial application of competition law in European Union will have demystified all philosophical gulf, and from its conduct to the effect, it has been applying the effect doctrine to its jurisdictions, and the extraterritorial application of European Union competition law may remain a subject of discussion. Nonetheless, the European Union's approach involves implementation doctrine, single economic unit doctrine, effect doctrine, principles of comity and the principles of cooperation, and the Court of Justice, European Court of Justice, in catena of cases have been very meticulously culling out and embellishing the entire jurisprudence of the competition laws and policy in a very proactive and a positive manner, and giving a wider application of extraterritorial application of the competition law through the instrumentality and of the doctrines and principles in a very amicable and an effective manner. With this, dear learner, I conclude my lecture and I wish a happy learning to you. Thank you very much.